In this video, we'll cover the second of two defenses to enforceability that is codified under Article 2, the doctrine of unconscionability. And here we'll start with some context. Unconscionability is just one of many contract law doctrines available to police the bargaining process. That is the process that led up to the mutual assent of the parties. As you know from your study of the common law of contracts, the common law already supplies various doctrines that enable a court to avoid enforcement of agreements, because something tainted the bargaining process that led up to the assent of one or both parties. Indeed, this list is only a partial list. We could add to this list other defenses, beyond the well-established doctrines of fraud, duress, mistake, and excuse. A contract may be voided because one party lacks capacity to contract, because they are minor or otherwise lack mental capacity. Likewise, a contract may be voided because of illegality or because it violates some public policy, where enforcement of the contract would run afoul of some law, for example, a criminal statute. Each common law doctrine allows one party to void a contract in light of a specific defect in the bargaining process, the process that led up to the assent of the party. And with all of these other policing doctrines, arguably unconscionability is unnecessary. More problematically, unconscionability undermines the freedom of contract. The freedom of contract is a bedrock principle of contract law and our nation's tradition of personal liberty. Under the freedom of contract, individuals, not the state, choose which contracts to be bound to. If an individual voluntarily assents to a contract, then the government, the courts, must enforce that contract with the force of law. The government, the courts, the state more generally, do not get to choose for individuals which contracts to enforce. Unconscionability undermines the freedom of contract because it enables courts to pick and choose which agreements to enforce. Under the doctrine of unconscionability, a court may refuse to enforce an agreement simply because a judge does not like the terms that the parties agreed to. But the freedom of contract is not the only value at stake here. The freedom of contract is a value that must be balanced against other competing values. For example, the desire to do justice, to ensure equity, to avoid enforcing agreements where the terms are manifestly unjust. In this respect, unconscionability serves as an important catch-all doctrine for the courts, providing the courts with a flexible tool to ensure justice and fairness where the other more established doctrines of contract law do not fit the case. Though the doctrine of unconscionability is deeply rooted in a desire to ensure equity, it's critical for you to understand that unconscionability is not the same thing as unfairness. Unconscionability is not a doctrine that courts may invoke willy-nilly to police or fix bad deals. Parties are free to negotiate and enter into good deals and bad deals. To find unconscionability requires something more than mere unfairness. So how should we try to understand this doctrine, its content and scope? Well, when dealing with the UCC or any other statute, your first answer should always be to start with the statute. Indeed, Article 2 codifies the doctrine of unconscionability in Section 302. 302 provides another good opportunity to practice our skill of statutory interpretation. Note that the statutory text here starts with a conditional if clause. If the court, as a matter of law, finds the contract or any clause of the contract to have been unconscionable at the time it was made. So with this if clause, we learn two things. First, a court must make the finding of unconscionability, whatever that term means. It's a question of law decided by the judge. It's not a question of fact that is decided by the jury. Second, temporally, the court looks only to see if the term or contract was unconscionable at the time the contract was formed. Unconscionability is not concerned with things that happen after a contract is formed, things that might make the terms of the contract more favorable to one party. Stated differently, changed circumstances arising after a contract was formed have no impact on the unconscionability analysis. If the condition in the if clause is met, that is, if the court finds unconscionability, then the statutory text says the court has three options. The court may refuse to enforce the contract, or it may enforce the remainder of the contract without the unconscionable clause, or it may so limit the application of any unconscionable clause as to avoid any unconscionable result. So, the court may first refuse to enforce the entire contract, second, refuse to enforce the unconscionable term, enforcing the rest of the contract with the unconscionable term or terms omitted, or third, the court may choose to judicially rewrite the unconscionable term or terms so that the contract is no longer unconscionable. That gives us some sense of who and how the unconscionability determination is made, but we still need to know what the statute means by the word unconscionable. As with any term used in the UCC, we might start by looking to see if UCC provides a definition for unconscionable. But unconscionable is nowhere defined in the UCC. Where a term is not defined by the statute, a good second step in interpreting a UCC should always be to consult the official comments. And indeed, comment number 1 provides slightly more detail on what unconscionability means. The basic test is whether the clauses involved are so one-sided as to be unconscionable. Of course, this test provides us with only a circular definition of unconscionability, but it also suggests that one-sidedness is not enough, that there is some threshold of one-sidedness necessary to establish unconscionability. The comment goes on. The principle is one of the prevention of oppression and unfair surprise. This sentence suggests that the core principle in unconscionability is to prevent oppression and unfair surprise. Courts have interpreted this comment to mean that there are two distinct facets to unconscionability. One facet is concerned with the prevention of oppression, what's referred to as substantive unconscionability. Another facet is concerned with unfair surprise, what's referred to as procedural unconscionability. With respect to substantive unconscionability, the court looks to the substantive terms of the contract. Are the terms so overly harsh or one-sided that they are grossly unfair to one party? Do the terms genuinely shock the conscience of the court that anyone would willingly and voluntarily agree to these terms? With respect to procedural unconscionability, the focus shifts away from the substance and terms of the contract to the bargaining process that led up to the formation of the contract. Was the bargaining process leading up to one party's assent somehow unfair or tainted? Was one party able to take advantage of the other party, perhaps because the other party lacked a meaningful alternative other than to agree to the terms being offered, perhaps because of an inherent inequality in bargaining power that allowed the more powerful party to essentially dictate and impose its terms on the weaker party? The lack of bargaining power may be exacerbated where the weaker party had little or no notice or understanding of what she was agreeing to because the unconscionable terms of the contract were either inconspicuous, hidden in a maze of fine print, or drafted in indecipherable legalese, making it impossible for the average person to understand what they were agreeing to. A majority of courts require some element of both substantive and procedural unconscionability before holding that a contract or some provisions of a contract are unenforceable. This reflects a judicial hesitance to upset the freedom of contract too sharply. A minority of jurisdictions, however, impose a sliding scale test, where an overwhelming showing of either substantive or procedural unconscionability alone could be sufficient and make up for the absence of the other element. So now we have a sense of who gets to decide what is unconscionable, how that decision is to be made, and what the general test for unconscionability is. Beyond these basic points, however, it's impossible to discuss unconscionability in any further detail. That's because unconscionability is an inherently contextual, fact-based doctrine. Stated differently, what makes something unconscionable is all about the facts and circumstances of a particular case. And even courts, trial judges and appellate courts, looking at the same underlying facts, will commonly disagree about whether a contract term is unconscionable. One thing to keep in mind, however, is that because the tension that the doctrine creates with the freedom of a contract, all courts are always reluctant to invoke unconscionability as a defense to the enforceability of an otherwise valid contract. To deny the enforceability of a contract that the parties have otherwise voluntarily agreed to, it's not enough for a court to believe that the contract terms were unfair. Something substantially more than unfairness is required for the doctrine of unconscionability. With the doctrine of unconscionability behind us, we have covered the two basic defenses to enforceability codified under Article 2. With next week's module, we will assume that we have an enforceable agreement, that is, we have a contract, an agreement for which there is no valid defense to enforceability, and we'll move on to a new topic. What are the legal rights and obligations arising under that contract? What are the terms of the deal?